because I thought about talking about it yesterday. I was probably driving, yeah. In COVID, I know. Well, he eats and so do you. So
All rise. First District Court of Appeals now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning. Welcome to the First District Court of Appeal. We have one case on the docket this morning at CNS Wholesale Groceries versus Division of Alcoholic Beverages and Tobacco. It's case number 22-2940. Mr. Davis, are you ready to proceed? You may proceed.
If it pleases the court, my name, of course, is...
Would you grab the mic and move it a little closer to you?
I'll stand a little closer. How's that? Can you hear me?
That's better.
Okay.
Thank you.
I'll try to get a little closer to it. My name, of course, is Riley Davis. I am representing the appellant, CNS Wholesale Grocers, in this appeal. As the court is aware, CNS Wholesale...
Mr. Davis, you going to reserve any time?
Oh, yeah, give me about 5 minutes.
Okay.
Okay. CNS Wholesale has appealed a final order of the Division of Alcoholic Beverages and Tobacco, which denied its challenge, or denied and dismissed its petitions challenging the request by CNS for a tobacco tax refund under Chapter 210.
So you filed the initial petition on October 13th of 2015.
Well, I think it was, no, that was, yeah, it could be October, it could be August. I can't remember if it was August or October.
So the petition was timely filed.
Yes, the
Okay.
petition was timely, and that is agreed to by the division, and is also stated in their final order that we timely filed the petition challenging the denial of the tax refund. And so when we did that, when we filed the petition, that petition did specifically simply state that the tax statutes involved were in violation of the United States Constitution, in violation of the Commerce Clause and the
So normally when a petition is filed, the department has 15 days from receipt to either grant or deny the petition.
That's right. Now,
And they didn't do
They didn't
either
do
one.
that. What in effect happened here is when we filed it, in the petition, we requested that the division delay sending the case over to Dole. We heard absolutely nothing from the division, and CNS assumed that it had, the division had in fact, taken the petition and was going to consider the petition whenever we got ready to present it. So that went on really for about 5 years.
Well, Counsel, specifically what you told them is that you want them not to forward it to DOA because there was a substantially similar case pending in the Ninth Circuit. So somehow it was tying the request not to forward this to DOA to that circuit court decision in Orange County. My question for you is, what would your client have done if, let's say it was at McLean, If McLean had won their lawsuit, say, 6 months after this petition was filed, what exactly would that have meant for your client?
Well, I think at that point, the client would have, in effect, requested DORA to transfer requested the division to transfer this case to DORA or for the division itself to consider.
What effect would that
Well,
order have
the
had
effect-
on this proceeding?
The division very clearly, and no state agency has the right to determine the constitutionality of a statute. There's no question about that. That's well, documented. What would have happened is we would have gone to a hearing, presented whatever we wanted to present, talked about the constitutional issues. If we'd have had a informal hearing, for example, before the division, which is what the APA guarantees and what Chapter 72.011 guarantees, we should have a right to go to the hearing, discuss the matter. The division could have conceivably been concerned about the constitutional issue, could have decided to even settle the case with us for one reason or the other. But what the APA guarantees under 120.569(1) is that you are entitled to some kind of a hearing, whether it be informal or formal, under Chapter 72011, which applies specifically to various taxing statutes, and in this case, Chapter 210, the statute that we're involved in. You have the right to elect to go challenge, in this case, a denial of a tax refund, either go administratively or go into the circuit court. It's your choice. There is no restrictions or otherwise, other than you must file that challenge within 60 days.
And you did that?
And we did that.
Okay.
No question about that.
But I mean, what obligation? I mean, certainly the department was under some obligation to try to move this case along, but what obligation did the petitioner have to move this case along?
At this particular stage, absolutely none.
Well,
We
specifically after McLean was dismissed, there was an additional 6 months before an amended petition. It seems like on both sides there was not a lot of effort into making sure things were going forward, and I don't know who the burden was on at any particular time, but the ball seemed to be dropped several times.
Yeah. Basically, we all know that in a circuit court, a plaintiff has an obligation to try to pursue his case and move it along, and if it doesn't get moved along, it could potentially get dismissed. That's very clear. But under the Administrative Procedure Act, the burden is on the division to get the case going. Once the party that is substantially affected by the action or inaction of the agency files their petition, the agency under 120.69(1) has the duty, responsibility, and mandate to, in effect, go and enter some kind of an order.
Well, I think you're generally correct, but you told the agency, hey, we're filing this petition, so it's timely filed, but there's this case out there, and we want you to wait. And essentially, that's what the department did. They waited. So normally they would be required to, grant or deny, but what happened is they waited because you asked them to wait. And so what obligation did you have to monitor the case you referred to and tell them when it was over?
I think certainly once the case was over, or particularly if the case had been decided, we would have obviously told them about it. But what happened in this case, CNS assumed that when it filed a petition and the division entered no order objecting to the petition or instructing us that they don't have jurisdiction or they don't have this or they can't do that, CNS reasonably assumed that the petition was accepted by the division. And so it sat there until CNS was basically ready to go. Now, keep in mind what happened in this case also. This went on for 5 years. All right. Then CNS, without any action from the division, then CNS filed a amended petition 5 years later. And when they filed that petition, in the cover letter or transmittal letter, CNS specifically requested the division to transfer this matter to DOR. Absolutely no response from the division. Now, they had the direct obligation at that point, without any question, to do something. They did absolutely nothing at that stage. 2.5 years later, after the amended petition was filed, the division, out of the blue, issues this final order, dismissing both the initial petition and also the amended.
So what were the differences between the initial petition and the amended petition?
There was a count on the amended petition. There was a count added where CNS was disputing how the division calculated the tax, the amount of tax that was actually owed.
But they were both based on the same tax years and the same
tax
pay.
But it was the procedures, what they looked at, what they didn't look at. And there was a case that we cited where the agency was not supposed to go, and in this case you had an intermediary distributor involved. We had these tobacco products were originally brought in or by another distributor, and then the way it worked, CNS was the distributor that actually distributed the tobacco products to the retailer. Well, we were maintaining that what we were maintaining and what this case said was that the division is not supposed to calculate the tax based upon what CNS paid to that intermediary distributor. Instead, they could only tax the tobacco products based upon what the manufacturer actually charged initially, and that was the big issue. But
So, Counselor,
we didn't ever get to that point.
You would agree that without the original petition, somehow somebody found out that, wait a minute, this 2012 case, we can use that to show that the refund should have been granted, and that happened in whatever it was, 2020, I think. That couldn't have been filed but for the original petition.
Right. Yeah, this all involves, as far as filing that amended petition, you've got to agree that the relation back doctrine in the state of Florida, which is really well ingrained in Florida jurisprudence, applies in this kind of a case. I think it clearly does under the Uniform Rules of Procedure, which is governs this particular administrative proceedings.
Well, Counsel, just out of curiosity, if this second argument had not occurred to your client, what would have happened to
Well, what would happen is
petition?
this.
Was it just going to be,
the
would
division,
we not even be here? Would it still be pending?
What would happen is that ultimately the division would have done what it did, let's just say, or we would have asked, pursued and said, we need a hearing, we got to get this thing resolved. But what we are in a kind of a quagmire because we must go, the 72.011 authorize the taxpayer, CNS in this case, to either go administratively, go through the administrative process, or go into circuit court. Once you choose, you can't go back to the circuit court. In this case, CNS chose to go the administrative route and go through the administrative process. We need to have some kind of a hearing to put us into a position to be able to raise the constitutional issue before this court, which it has every right to determine the facial constitutionality of the statute. The division in this case, by denying the petitions, we're not even in a position to come before this court and argue the facial constitutionality of the statute, and that's just simply intolerable. And you have a rule in the administrative code on Uniform Rules of Procedure that specifically gives the right to the relation back issue. But even if we weren't even involved in that, we would have a right through division order, working with the division, whatever, to at least go to an administrative informal hearing. Now, what could have happened here, let's say that other case did not come up and we never knew about it or raised it or otherwise. What would have happened is that if the division had entered an order like it was supposed to, and that's mandated under 120.569, paren 1, if they had issued an order saying, we got a problem with this case.
Mr. Davis, I don't want to interrupt, but
Okay.
you're into your rebuttal time. You may continue if you want.
Yeah, let me just finish up one thought and I'll say, if we had actually if the division had entered an order and said, we got a problem, all right, we could have adjusted what we did. We could have turned around and said, what we want is an informal hearing. And I think under 125.69(1), we would have been entitled to an informal hearing. Keep in mind that the division has jurisdiction over this controversy because of 120.569(1) and also 72.011. The Administrative Procedure Act and the administrative process is not a got you type statute. The legislature gave us the ability to go either way, and for whatever reason, CNS chose the administrative route on this particular matter, and we should not be penalized by doing what the statute specifically authorized us to do.
All right, thank you. I'm going to grant 2 additional minutes to each side so you can get a more robust rebuttal time.
All right.
And Ms. Adams, you'll have that extra 2 minutes if you want to use it.
May it please the court. Good morning. My name is Brooke Adams, and I represent the Appalachia, Florida Department of Business and Professional Regulation, Division of Alcoholic Beverages and Tobacco. This court should affirm the division's order for 3 reasons. First, neither the division nor DOA has jurisdiction to consider either of appellant's claims. Second,
So the original petition was timely filed, correct?
it was timely filed on the 60th day as required under...
Well, that doesn't matter, does
Yes.
it? Okay.
That's-
So it was timely filed?
It was timely filed,
Okay.
yes.
So usually the division has basically 15 days to grant or deny,
That's correct.
and nothing happened. That
Correct.
was- The
Here-
division didn't file any orders. They didn't send a letter saying, hey, we're gonna wait because you seem to want to wait on this. They did nothing.
No, it did not. It did not respond, but it did exactly what the appellant asked it to do, which was hold the case and not forward it to DOA.
Okay.
And
Counsel, let me pick up where Mr. Davis left off on that exact point. Paragraph 13 of the final order issued in 2022 says the first petition cannot be indefinitely held while waiting on an indeterminate outcome in an unrelated case. Isn't that the first and only time the department addressed the, motion to stay, or whatever you want to call the second paragraph of the petition?
it's not apparent from the record, and from the record, this is the only time that we can see that the division did address appellant's request that
I mean, wouldn't the first 15 days have been a really good time to do that?
it would have. However, an agency's failure to follow prescribed procedures only mandates reversal if there's a showing that the harm impaired the fairness of the proceedings or the correctness of the outcome here. And here there
Well,
are
the fact
two.
was is they were entitled to a hearing at some time, and they didn't get a hearing.
Yeah, where would their point of entry be? Like before the final order, when somebody, figured out the problem, shouldn't there have been some kind of an opportunity to be heard before a final order just arrives in the email?
Perhaps. I have a couple of points I'd like to make in response to your question. So I want to point out that appellant filed its initial petition on the 60th day as required under 72011. And in that petition, it raised one claim, and that was a challenge to the facial constitutionality of provisions of Chapter 210. It's well-settled Florida law that administrative tribunals lack jurisdiction to consider these types of claims.
Well,
Yeah, but
they
you
lacked
should-
sorry, go ahead.
But usually when you have a constitutional claim before DOA, you go and you build your record, you raise your constitutional claim. The ALJ doesn't have the jurisdiction to rule on that, but then we get a record with an argument that's made before the ALJ. It comes here, and we are able to determine whether the constitutional claim has validity or not. But
Yes.
you get a hearing to build that record so we can see what happened below.
So here, the problem with appellant's case is that it raised this one claim that DOA didn't have jurisdiction to consider, the division didn't have jurisdiction to consider, and then it sat on the claim for 5 years, and it attempted to revive its claim by bringing a claim that was time-barred under 72011, which requires claims be brought within 60 days. That's a statute.
So I'm trying to understand what you're arguing. You're arguing that both claims are time barred, but the original claim on the constitutionality was filed timely, and apparently there was an informal stay granted by the agency. So arguably, is that one, does that one survive? Is Mr. Davis entitled to hearing on that claim?
To which claim, the first one or the second?
The first claim, the first
first.
petition that had the one claim, the constitutionality argument.
No, it is not, because it's one claim that administrative tribunals lack jurisdiction to consider, and so that was fatal in and of itself. And then it's time-barred second claim.
No, if they hadn't have asked for this informal stay, what would have the agency done? Would they denied it because it was a constitutional claim?
Yes, it would have been
Without sending it to DOA and without building a record?
Correct.
I mean, certainly the agency doesn't have the authority to rule statutes unconstitutional, and they should have denied it. But usually it goes to DOA, and everybody puts forward their evidence and their arguments, and then it comes up here on appeal.
In this particular situation, since appellant only brought this one claim, the division would have denied it at that point as well. Some of the cases that appellant relies on are situations where an appellant brought two claims, one being a constitutional challenge that administrative tribunal lacked jurisdiction to consider, and then another being a claim that the lower tribunal could consider. Here, the problem is that we had one claim only that administrative tribunals lacked jurisdiction to consider, which is why that one would have been dismissed with prejudice. And then moving into our second argument, appellant's amended petition was completely time-barred. They attempted to
If their
revive.
only claim was a constitutional argument, what does it matter what this other case held? Why didn't you just deny it?
Because we were doing exactly what the appellant had, or I'm sorry, the appellant had asked the division to do. We were holding it because they requested we hold it based on some other case, and they didn't follow up. We didn't hear from them for 5 years, and that's when they brought their new
Well, they didn't
petition.
hear from you for 5 years either, so it's kind of, there are good arguments on both sides. Is there any procedural rule that requires that a request for relief be in a separate document or in a motion, something titled a motion, so it'll kind of be on the docket and trigger any action by the division?
Not that I'm aware of
Okay.
in this context. But I would like to talk more about appellant's claim about the amended petition where it raised the time-barred complaint. Appellant claims that the relation-back doctrine applies here. However, it does not. And the first, second, and third district courts have issued opinions in which they have declined to apply the relation-back doctrine in a context of a statute of non-claim like here. And
So
72.
what's the first DCA case?
Sowell versus Faith Christian Community. It was issued in 2018. And that one, the appellant there challenged a property tax denial of some sort, and this court held that the relation-back doctrine could not revive its initial petition, and there were a couple of jurisdictional problems at issue in that case, but the one that's most applicable here is that there was an untimely amended petition, and the court held that the relation-back doctrine could not apply here in the context of a statute of non-claim.
How does the administrative rule, which allows these petitions to be amended, fit into this question?
So the administrative rule is akin to the relation-back doctrine under Florida Rule of Civil Procedure, and since several courts have held that the relation-back doctrine does not apply in a statute of non-claim, it would follow that the administrative rule allowing petitions would also not apply in the in the context of a statute of non-claim.
Are there any other, maybe I should direct this to Mr. Davis, but are there any other cases pending in the pipeline for different refund periods that raise the cigar industry equal protection argument?
There are, yes, and there actually was one, a PCA issued in this court with CNS as a party, and they also, in that case, raised the same constitutional challenge that they do here. And then I would like to get back to my points about how the division delayed in ruling on appellant's petitions and how that was a harmless error. As I stated earlier, an agency's failure to follow prescribed procedures only mandates reversal if there's a showing that it impaired the fairness of the proceedings or the correctness of the result. Given that neither the division nor DOA has jurisdiction to consider either of appellant's petitions, the result would not have changed. And something that's
Well,
very...
counsel, just to follow up on what Judge Roberts was talking about, if, let's suppose, again, they did not ask you to hold it. You simply looked at the petition and said, oh, this is a constitutional claim, we can't consider that, it's dismissed. They appeal it. They appeal that. Now, given what Judge Roberts has said about what we can do with constitutional claims, what would have happened if you had refused to give any hearing at all to the constitutional claim and it had come up here? And they say that we had a right to be able to create a record on the constitutional claim.
It seems like that is exactly the situation that has happened, and appellant failed to follow the required administrative and statutory requirements to successfully make this type of challenge, and I think that's partly because they filed one claim 8 years ago now that neither the division or DOA had jurisdiction to consider, and then 5 years later it filed a time-barred complaint. So I think now our hands are tied because nobody has jurisdiction to hear its claims. Had they brought two claims initially and timely before the time period had expired under 72011, we would be dealing with a different situation, but that's not the case here. And I think it's also telling that when appellant filed its petition for a formal administrative hearing and requested that we withhold from sending it to DOA, they raised the McLean case, which was later voluntarily dismissed. But when it filed its amended petition, it brought up a completely separate case that had been decided prior to the tax refund challenge period that it was bringing up here. So it seems as if its initial petition was a red herring or a placeholder petition, and the jurisdictional requirements in 72011 make clear that these types of claims have to be brought within 60 days, presumably because the legislature wanted to cut off the time period for bringing these. So 8 years later is probably not contemplated by the legislature under the subsection 5 of 72011.
I think we're in a, not contemplated is the problem. I mean, all over the place on both sides, this wasn't contemplated. Are there any cases, rules, or statutes directly on point with these facts?
When it comes to the amended petition, there are...
The whole idea of would you please hold this, and then it just crickets, for 5 years. I mean, I couldn't find any, and I don't think anybody cited any. We're looking at general propositions. And so when you have a case where there's due process considerations and there's really nothing, there's no clear, red cow standing in the field case that tells us what to do, why shouldn't the tie go to the runner when you're dealing with a private, a taxpayer and a state agency?
Because here in this situation, the time period has long passed and neither the division nor DOA has jurisdiction to consider either of these claims at this point. So I'd also like to bring up that Judge Roberts, you brought up, we may have touched on this already, how the division did not respond to the initial petition. There are 2 points I want to bring up about that. One, if the division had responded to that and it would have dismissed the petition that day, no amendments would have revived or helped its claim at that point because it filed that petition on the 60th day required. And so any amended complaint at that point, even if we had given them a chance to amend it, would have been futile because it would have been time barred. And then another point that I wanted to bring up was that they're precluded from arguing that they were deprived of due process based on that by the invited error doctrine because they specifically requested that we not forward its case to DOA, and the division did exactly what it had requested. And this leads me back to my overarching point that there is a harmless error here. A due process error is harmful if there's a reasonable probability that the result would have been different but for the error. But here, given that the division lacks jurisdiction to consider both of these arguments, DOA lacks jurisdiction to consider both of these arguments, and that this is reaching this point 8 years after the initial tax challenge had been filed, despite the fact that 72011 makes clear that these types of claims have to be brought within 60 days. I think it's easy to conclude that any error is harmless at this point. And if you have no further questions, then we request that you affirm for these reasons.
Thank you.
First of all, I'd like to make a couple of points, which I think is very interesting. Number one, when the division finally entered its final order, that final order never raised the issue of the sufficiency of the petition, the original petition, from the standpoint that the division had no jurisdiction to consider this matter. It simply stated, and what the division had concerned about was the fact that we, or CNS, had requested that the matter be stayed. And they took the position, or not referred to, or they took the position that that made the petition insufficient. Right? Well, if that was their position, if they had said that to us way back when the petition was filed, fine. We could have tried to address that issue. Instead, we end up in a situation where we are being precluded from going through the administrative process, building a record regarding the constitutional issue and presenting the constitutional issue before this court that we have every right to do, based on the division's position now that it has no jurisdiction. Well, we were fully aware.
Well, let me stop you then. What if, on that exact point, if they had issued a final order within days of your petition saying the exact same thing, that, sorry, we dismiss this petition because we cannot consider it because it raises a constitutional matter, would that have been proper? Would that have been appropriate?
They would have to have told us in detail, et cetera, under that statute, why they were dismissing the petition.
Okay, if they had done that, is what I'm trying to get
yes,
at.
now they have,
It would have been appropriate for them to say, and presumably if you had appealed, we would have affirmed, if the division had simply said, we can't consider constitutional challenge, case dismissed.
All right. If they did that without giving us a hearing, without giving us an opportunity to discuss, then we would have been back in the same position from the standpoint of having to appeal that order to this court. But what we are maintaining is that that order would have been in error just like this order is in error, and that is under the Administrative Procedure Act and also under Chapter 72. We are entitled to some kind of a hearing. That's what the Administrative Procedure Act is all about. It is not, this Chapter 72.011(1) says you can go through the administrative process or you can go into circuit court.
So do
we chose,
from your perspective, if they had done that, that would have been reversible error?
Yes.
What I described. Okay.
Absolutely. And to sit back here today arguing that we invited the error, in my opinion, is preposterous. We simply stated in the petition we would like to delay forwarding this matter to DOR. The division made no response whatsoever to that. Now come before this court today trying to maintain that the CNS somehow invited the error because we requested that, when the division clearly has the requirement and mandate that it actually enter some kind of order within 15 days, of the filing of the petition as to whether or not they're going to accept it, deny it, or what problems they may have, and then at the same time give you a chance to amend or take some kind of other action. But we had no notice of anything. And so we respectfully request that this court vacate that order and remand this case back to the division for either an informal hearing where we can build a record on the constitutional issue, or send this case to DOR if you agree with CNS's position that the relation back doctrine does apply. In this case, we had a right to file that amended complaint. No action had been taken by anybody. Nobody is harmed by applying the relation back doctrine in this case. And as we all know, the relation back doctrine is well ingrained in the judicial doctrines of this state and readily granted in almost every case to try to, in effect, perfect justice in any case and develop a record, etc. Thank you.
Thank you both for your arguments. We have no other cases before us, so we are adjourned.
All rise.